Welcome back to the Global Business Channel. Thank you for joining us again today. In this video, we'll be discussing the limited liability of shareholders in companies. First, we'll define limited liability. Second, we'll delve into how limited liability works. Third, we'll examine limited liability in relation to existing and incorporated entities. And finally, we'll review some provisions of shareholder liability under the Mauritius Companies Act 2001, as that is the country in which I operate and work. We publish weekly videos on topics related to offshore global business, corporate, financial, and compliance sectors. We encourage you to subscribe to the channel and give this video a thumbs up if you find these topics interesting. Without further delay, let's get started with today's video. Limited liability refers to a legal framework in which an organization's financial liability is limited to the amount invested in a partnership or a limited liability company. This means that the personal assets of investors, shareholders, and/or owners are protected in the event of a company's failure. In Germany, for example, this concept is known as Gesellschaft mit beschränkter Haftung, or GmbH, or in German GmbH, whereas in France, such is known as Société à responsabilité limitée, or SARL. The limited liability provision is a significant benefit for investors or shareholders. It allows them to benefit from the company's growth potential while ensuring that their financial responsibility is capped at the initial investment, even if the company faces insolvency and outstanding debts. When an individual or a company operates with limited liability, it means that the personal assets of the associated individuals cannot be seized to repay the company's debts. Only the funds directly invested in a company, such as through the purchase of company shares, are considered company assets and therefore can be seized in the event of insolvency. Other assets in a company's possession, such as real estate, equipment, machinery, investments made in the company's name, and any produced but unsold goods, are also subject to seizure and liquidation. Without limited liability as a legal protection, many investors or shareholders would be hesitant to acquire equity in companies or otherwise acquire or subscribe to shares, and entrepreneurs would be wary of starting new ventures. This is because creditors and other stakeholders could claim the investors' and owners' personal assets if the company incurs losses exceeding its assets. Limited liability prevents this, ensuring that the maximum loss is limited to the amount invested, with personal assets remaining protected. When a private company is incorporated, it grants its owners or shareholders limited liability by establishing the company as a distinct legal entity. This separation is crucial for industries prone to significant losses, like insurance. In the United States, a limited liability company, or LLC, shields owners from personal liability for the company's debts. LLCs blend corporate features with those of partnerships or sole proprietorships. While LLCs offer limited liability akin to corporations, they also provide flow-through taxation to members like partnerships. Unlike partnerships, an LLC safeguards owners' personal assets from the company's debts. For instance, consider the plight of Lloyd's of London names, individuals who assume unlimited liabilities for insurance risks in exchange for premium profits. In the late 1990s, many went bankrupt due to massive losses from asbestos claims. In contrast, shareholders in major bankrupt public firms like Enron and Lehman Brothers lost their investments without being personally liable for the company's debts, totaling billions post bankruptcy. Limited liability serves to segregate and safeguard personal assets from business assets. In certain nations, unlimited liability corporations can be formed, where shareholders or partners bear full responsibility for the company's performance and debts. In the event of insolvency, the unlimited liability partner must repay all incurred debts to creditors. Let's now take a moment to go through the major provisions of the Mauritius Companies Act 2001 regarding shareholders' liability. We will be summarizing the relevant sections, but do take a moment to pause the video to read through them if you will or want. Section 2 regarding interpretations has a few references to the liability of shareholders. A company limited by guarantee refers to a company established on the principle that the liability of its members or shareholders is limited by its constitution or governing documents to a specified amount that the members or shareholders agree to contribute to the company's assets in the event of it being wound up or liquidated. A company limited by shares refers to a company established on the principle that the liability of its shareholders is limited by its constitution to the amount unpaid on the shares they respectively hold. A company limited by shares and guarantee refers to a company established on the principle of limiting the liability of its members as follows. A. For shareholders, the liability is limited to the amount unpaid, if any, on the shares they hold. And B. For those who have given a guarantee, the liability is limited to the amount they have agreed to contribute both periodically and in the event of the company being wound up. And finally, an unlimited company refers to a company established on the principle that there is no limit on the liability of its shareholders. Section 32 regarding the name of company where liability of shareholders is limited states that when the liability of a company's shareholders is limited, the registered name of the company must end with the word limited or limité or the abbreviation LTD or LTEE. However, as per the 13th schedule of the Mauritius Companies Act 2001, Section 32 does not apply to a company holding a global business license, or if it has been incorporated as an authorized company. In Mauritius, the former means that they are considered offshore companies. Section 100, which concerns the liability of shareholders, states in subsection 1 that, subject to a company's constitution, a shareholder is not liable for the company's obligations solely by virtue of being a shareholder. Subsection 2 stipulates that, subject to a company's constitution, a shareholder's liability to the company is limited to A. Any unpaid amount on a share held by the shareholder, B. Any liability arising under Section 128 to C. C. Any obligation to repay a distribution received by the shareholder to the extent recoverable under Section 66. D. Any liability expressly stated in the company's constitution. And E. Any liability under Section 101. And subsection 3 argues that this section does not affect a shareholder's liability to the company for A. Contractual obligations, including those for the issuance of shares, B. Any delict, C. Any breach of fiduciary duty, D. Any other actionable wrong committed by the shareholder, and E. In the case of an unlimited company. And finally, the last section of the Companies Act regarding the liability of directors, shareholders, and others, which is found in Section 317, states that the removal of a company from the register of companies does not absolve any former director, shareholder, or any other person from liability for any act or omission that occurred before the company's removal. This liability persists and can be enforced as though the company had not been removed from the register. That's it for today's video regarding the liability of shareholders with regard to companies. Thank you for sticking around until the end. Your support means a lot to us, and we hope you found the information, insights, and key points valuable. We'll continue to share informative content every week, so don't hesitate to return to the Global Business channel for insightful videos on the offshore, global, compliance, and financial services sectors. Take care, stay safe, and we'll catch you in the next one. Cheerios.